Welcome to Legal Eye on Health, your insight into health law, the ultimate podcast for unraveling the legal intricacies of managing a thriving medical practice. Join us for a deep dive into health law, specifically tailored for providers. Hosted by Dr. Katie Gilbert Spear, a seasoned health law attorney and practicing optometrist, as she brings her unique perspective and passion for empowering fellow practitioners. Together, we'll tackle the pressing issues confronting providers daily. Welcome to Legal Eye on Health.
Are you looking for a nutritional supplement to help with your day-to-day vision needs? Look no further than MacuHealth. Recommended by doctors worldwide, MacuHealth offers a full line of products designed to support your vision and eye health. Available through eye care professionals on Amazon.com and directly on our website at MacuHealth.com. Use the code LEGALEYE when ordering directly from MacuHealth for special discounts. MacuHealth, nutrition you can see.
Welcome back, everyone. I'm here with Dr. Katie Gilbert Spear. I'm Dr. April Jasper, and together we're going to talk health law. So, Katie, I want to start back with a question that I think really helps set the stage for all of us in practice, whatever type of practice we're in. I want to ask that question of what are the three areas that we need to be focused on when we think legally where our attention should be in our practice?
So, April, I think that there are three main areas of liability in our practice. There's probably others, but in my head, I couch them in three areas. One is patient care. And that when we think about patient care liability, we think about malpractice typically, standard of care violations, things like that. Other areas of the practice where we could have liability or potential compliance issues would be like insurance, billing and coding, right, the contracts that you have with different insurers and things like that. And then the third area is really statutes, federal law, state law statutes and rules that are different in every state and change all the time that we have to abide by.
So go back to malpractice then for a minute. I think one of the key things that people need to understand, and by people I mean me, is really what constitutes malpractice.
Well, before I start with this, because this is the thing, it's one of those things where I don't know if you get, requests for records very often in your practice, but we do. And sometimes they come with an envelope that has an attorney's office on it. I don't know about you, April, but every time I get an envelope like that, my heart stops. Yeah. My stomach drops and you're like, oh my gosh.
What now?
What is this, And usually it's somebody with a disability claim or something like that you just need to provide your records for. But malpractice can be the one thing that really just, can really set us off and really cause a lot of anxiety. The good news is that in the optometry world, we don't have a lot of malpractice. I mean, yes, it's there. Don't get me wrong. It happens all the time, but not all the time. It's rare compared to other practices of medicine. We just don't. Typically, your surgeons, they just get sued more often. And so ours are usually... it's just not that often compared to other areas of medicine, which is encouraging. That's good. But even if you're not sued successfully, nobody wants to be in the middle. You don't want to go through it. Oh my goodness. Just the stress of that is awful. So that's the good news. But malpractice in general, before you can have malpractice, you have to have a doctor-patient relationship. That has to be solidified and formed. And then once you have the doctor-patient relationship, you have to provide the current level of standard of care for your profession. And, we're going to talk later about standard of care later in the podcast about what that means, because there's a lot of things around that. But once you have a patient, they're your patient, you have to provide an appropriate level of care. It's called standard of care. If you fail to provide that standard of care, you could have a malpractice claim, but you can only have malpractice if the patient had damage from your failure of care. And the problem with that is that damages is very broad definition. Damages, when we think of damages, we think of they lost eyesight or typically that's, in our world, that's what we think of. But there's all kinds of other, definitions for damages as well that we'll talk about later.
Okay, so let's start with that doctor-patient relationship because I mean, I've heard all kinds of different things, and I don't know the truth. I don't know what's real. So that's what you need to help us with. Tell us, how do we know when that begins? Define it, right? Shouldn't that be where we start?
Sure. Yeah. So the doctor-patient relationship is really determined, what can be determined by a lot of different things, but typically state statute. So again, what state you're in will play a key role in determining what what is used as a definition for, determining the doctor-patient relationship. It can also come about from like an employee contract. If you're an employed doctor, employed by like some type of company that you're providing patient care services for them.
Right.
It can be a contractual relationship. Different insurers may say that these are the patients you're seeing, so you naturally have a contractual relationship. And it can be from actual care, like when did you? Typically, each state will have a definition that says along the lines of, you as the physician have to acknowledge, the patient has to seek your services, and you knowingly accept them as a patient.
Okay. All right. So do you have any examples of kind of what you're talking about in medicine?
Yeah. And I think I want to point out two different cases. And you could pull cases from, a lot of different places, but I think these two are really interesting. So this one case came from Illinois. It was a mother of an infant, a new mom. Her baby got sick, was running a high fever, and she couldn't get in touch with her pediatrician. So she called her local emergency room. We don't know who answered the phone, but somebody answered the phone and said she claims that she was being overreactive, as mothers can be sometimes, and that a lot of infants have high fevers. Just give them a tepid bath and some Tylenol, and he'll be okay. And
this is what the hospital told her.
The person at the hospital said, yes, and is what she claims. And but the person at the hospital did tell her that whoever answered the phone didn't know what dosage of Tylenol that the infant needed, that they needed to call a pharmacist, and specifically that they did not have the equipment or medical personnel to provide medical services for infants.
For infants.
They told her. And actually she remembered the hospital person telling her that.
Oh, wow.
The infant got worse, and she ended up suing the hospital. And the hospital's claim, when they wanted to dismiss it, their argument was that they never formed a doctor-patient relationship. They never examined the child. So how could they be sued for anything?
Right.
And so it went to the court as did they form a doctor-patient relationship?
Yeah.
And the court ruled in favor of the hospital, and said that the physician and patient relationship is consensual, and the patient knowingly seeks the physician, and the physician knowingly accepts the patient. Because the hospital, whoever she talked to at the hospital, told her, we don't have the equipment nor the personnel to see this patient, your infant, that there was no establishment, even though they did give advice. So a lot of times when you read these doctor-patient relationship cases, it hinges a lot on what advice was dispensed and to who. So in this case, they did dispense advice, take Tylenol, tepid bath, but they specifically told her that they weren't equipped to see the infant.
Right.
So the court ruled in favor of the hospital. Now, contrast that to a Michigan case.
Yeah, tell us another way it works.
Where a cardiologist who was on call, he was the on-call cardiologist for the night, received a call about a patient who presented to the ER who was having heart palpitations. So the ER doctor called him for a consult because you're on call.
Yep.
And he gave the ER doctor advice to the point, gave, treatment advice and said, put him in a step-down unit and I will take it from there. Well, the ER doctor documented all of the advice that he was given.
As would I.
Yes. Unfortunately, the cardiologist did not and didn't remember the conversation. And the patient did not fare well and ended up, suing the cardiologist. And so the cardiologist's argument was, I never saw the patient's records.
Yeah.
I never saw the patient. So how did I form a doctor-patient relationship?
But they both worked at the hospital.
Correct. But the cardiologist never came in to examine the patient and never was not sent any records. He was told about the patient's testing and results and things like that by the ER doctor, but he never physically, looked at the chart himself.
Got it. Now,
the court rejected the cardiologist's argument and said you did form a doctor-patient relationship because maybe you didn't review the chart, but you were on call.
Right.
Now, being on call doesn't mean that you automatically form a relationship with every patient that presents, but you were the on-call cardiologist.
Yep.
And you talked to the ER doctor, and he did give you the patient's information, and you gave treatment advice.
Oh my goodness.
And then, so you did form a relationship because you did dispense. And so the court went on to say, if you did not want to form a relationship, then you should have said, I want to see the patient's records, or I'm going to come in, or I want a formal, consult agreement before I dispense any advice. So I think it's two cases that really show you the difference and how does this hint the court's definition and the state's definition on what case, law they're using to define when that relationship is formed.
But now you got to take it to what we do, because I can kind of see, I could see both scenarios.
Right.
So now a patient calls my office.
Right.
We've never seen them. And can we take it, maybe a red eye? I use that as an example.
And so this is where training your staff really comes into play, April, because who's answering your phone? Mm-hmm. If you've got someone who's dispensing medical advice to a patient that so typically if you've never seen the patient in your practice, you've not formed a relationship.
Right.
But when you start doling out advice, treatment advice, you blur that line of is this a patient?
Right.
Do we have a doctor-patient relationship or do we not?
Wow.
So if you've got someone answering your phone, hopefully they won't give out advice, but this is why it's so important to train your team, right?
Do not ever give advice on the phone.
Give advice.
Okay.
And I would say not advice. Your team doesn't need to be given advice. If you want to give advice with all your knowledge, then maybe so. But if they start giving out advice of, you've got a red eye, well, maybe you should do this. No.
Right.
You can get them scheduled to come in and see you, but I wouldn't give advice.
What about just the fact that they want to know how soon to come in? So you train your team. Number one, don't tell them a treatment because you don't know what they even have going on.
Correct.
And then make notes of the fact that you told them to come in.
Right.
I mean, in our office, I just tell them come in today.
Yes. And that's how we are too. I mean, obviously, if they're not your established patient, then you don't have to take any type of urgent or emergent. If you don't have somebody, if you don't have open space in your book, you don't have to legally take them. Now, if they're your established patient, you do.
Okay.
But obviously, I like getting patients in. I don't want them to suffer. So you just put the time frame that you want them to come in. Document.
Okay.
Mm-hmm.
Okay. So that relationship then, what you're saying is legally, and of course we're in Florida, that relationship begins with a new patient when they step in the door, but at the same time...
Not necessarily.
Okay.
There have been cases where it depends on how far they've gotten into the exam. So if you have a patient...
Oh, even in the office.
Right. If a new patient comes in and you've done nothing for them,
and now all of a sudden they say, I don't want to be seen.
Then
I don't like this person that's working with me. I'm out of here.
I don't want to pay the copay.
Right.
And they leave. You really,
relationship.
You would have a hard time establishing a doctor-patient relationship because you've given them, you haven't seen them, you haven't treated them, you've given them no advice. They didn't want to pay the copay and they left. And
they technically didn't even see the doctor still.
Right.
So now let me give you another example. It's a patient that is not, so let me rephrase it. The person is not your patient.
Okay.
It is one of your friends, the mom of one of the other kids that's in cheer.
Okay.
is sitting next to you and says, "Oh my goodness, I have this red eye, and you're an eye doctor, aren't you? Mm-hmm. What do I do about this?"
So I do not dispense advice without seeing them, and I tell them
office.
in the office because people want to send you pictures.
Yep.
They want to call you. And, I want to treat them. I want to help them. I really do. But at the same time, you know as well as I do.
You
have
put
no
yourself
idea.
at risk.
You're at risk because you have no idea what actually is causing the red eye. So I'll say, hey, if I'm out of town and they're not a patient, I will, send them to someone else or send them to one of my offices if I can. But I do not dole out advice because the more advice, because if they're relying on your advice, then you really start down that we may have formed a relationship now.
Let's say they text you. I mean, that's even worse in a sense because now whatever you respond, they have written record of. They have documentation of.
So I say, come in the office, let me see you. And I always say, because depending on what's causing the redness, that determines my treatment. And if I give you the wrong thing, it could make it worse.
Right. Well, and I've been doing this for almost 30 years now. And I will tell you, it's crazy the number of red eyes that have come into our office that somebody else started treatment for that were absolutely not on the right treatment.
Right.
One of my very first ones, Katie, in practice was a patient who came in on Tobradex. And I look at her, she has been getting worse for 2 weeks and she has toxoplasmosis.
Oh, wow.
She was never going to get better.
Right. No.
And she was only developing a bigger area of inflammation in her retina. She just happened to have it all over. Like the reaction was everywhere in her eye, but that's what they did.
Right.
And now imagine it's a kid. And we need to go down that road at some point and talk about your liability is greater with children.
Yes. Well,
Why?
They have longer time to see you.
There you go. Make it easy. And let me give you another example. So I know I'm making Katie go really into the weeds here. So we talked about the one that is the text message that you get from a non-patient.
Right.
What about the text message you get from a patient? Now you've already had a relationship, doctor-patient relationship, but this isn't truly an exam.
No, but at this point, you already have established a doctor-patient relationship. I'm not going to treat over that either for a red eye.
Okay.
Just because I don't know what's causing it.
Yep.
Because whatever treatment advice you give, you're held to.
Right.
So if you did the wrong one, it's going to be on you.
So what happens? I think that's something maybe we get into right now because we're early on in the podcast. Let's say they did do something wrong. Let's say that somebody did give advice. It went bad. Now they get sued. What's the worst that can happen at that point?
I mean, if the patient suffered damages, then whatever those damages are calculated to be, that's what you're going to be held to.
Okay.
And just in that scenario, you don't want to be in.
Right.
So I usually make them come into the office.
Yep. And I think what people don't know until they've been through it is even when you did nothing wrong, if you're going through a lawsuit, it is one of the most traumatic, painful things you can ever go through. I've been there, gone through it. I won't ask you if you have. You can tell people if you want, but I was miserable the whole time. So
one other thing I wanted to bring up about doctor-patient relationship is about consulting with other doctors.
Oh, okay.
Because that's another area. And if you've got a doctor, say you call me about a patient or I call you about a patient, I use your advice. Am I then can that patient
are you
sue
responsible?
Yeah, exactly. Have we done that?
Yep.
Most courts, not all, would say that if it's an informal advice, meaning you don't know the patient, you haven't seen the patient record, I'm literally just asking you a question. Hey, what would you use on a red eye like this? Would you use Tobradex or would you use this?
Yep.
That's pretty informal, and those usually don't form a relationship. But once again, the more detail you get and give, the more likely you are that you have formed a relationship, because there's a lot of case law around that whole consult too. When you asked advice from another doctor.
So a phone call is always better. It puts the other person at less risk because there isn't documentation.
Of you, yes. But if they document in their chart, well, Dr. Jasper told me that I should give this patient this and this. So you need to make it apparent that, hey, I'm just giving, I've not seen this patient. I don't know exactly what,
This is off the record.
But this is what I'm going to tell you for if it was a red eye with this is what I would do.
Right.
But do what's in your best judgment, what you think is your best judgment,
right.
because you have the patient right in front of you. So you just need to make it very clear.
Okay.
It's not like a formal consult,
And yet, if you're the one asking for the help,
yes,
and someone did give you help over the phone, would you write that in your record?
If it's another optometrist and I'm just asking their, opinion about a patient, then no, because it's informal to me.
Yep.
Formal would be, I'm seeking the advice of a retinal specialist or a corneal specialist, and I want to get them in with, I'm actually referring them.
Got it.
So they tell me, no, do this, this, and this. That's a little different.
Right. Or it's okay to do this and I'll see them in a week.
Right. Yes.
Okay.
I would
Okay.
document that. Yes.
Very good advice.
Yes.
So let's summarize. What
Sure.
have we talked about so far? We talked about the areas of liability or the areas of health law that we really need to be thinking about. So that was, let me see if I remember, liability, insurance, federal laws, but malpractice.
So malpractice would be like patient care.
Okay.
And then your liability as it relates to insurances that you take and all that. And then federal and
Statutes.
state law, kickback,
And
fraud and
okay.
abuse laws,
Okay.
those types of things.
Then we dove into just the doctor-patient relationship and
Right.
how that has to be established in
Correct.
order for you to even have any.
Malpractice liability.
Got it.
Yes.
I love it. All right. So we've learned a lot. This is a good beginning. Thank you, Katie. You have helped us so much to kind of understand and breathe easier.
Yes.
We promised everyone
Yes.
this wasn't going to be a stress you out type of podcast, but a make you feel better about the fact that you're doing things right.
Yes, you are.
Awesome. Don't miss our next episode.